Allotment of land. The land allotment of agencies, agency instrument, agency instrument organization, and institution which carries on the tag of caste, community, and religion. Political consolidation by way of favoritism, nepotism's view of nurture the vote bank of the future will be constitutionally impermissible. Akhil Bharatiya Shosh Congress. Prohibition of anti-competition agreement. The tendering process when different companies are quoted identical rates dispute huge differences in the production costs of incurred in Section 3 of Competition Act 2003. In a sad way that the tender had to be contravention, said Act Excel Corp Care Limited versus Competition Commission of India. Arbitration action of and discretion. The legislation discretion. வார்த்தை தரலான்னா எழுதணும். Discretion. In the case of special treatment without indicating a policy may be set aside the violent use of equality. What? Relative of equality. Okay. One of the hand provision that dies down the likely to uphill, but the other hand provision failed to give the guidance like to invalidate an important judicial decision of subject. In the state of West Bengal versus Anwar Kali, Meenakshi Mills versus Vishwanath, with the Singh state of Punjab, state of Singh state of Punjab. The law provides a special treatment of government to other public bodies held out this discriminatory, but that does not follow that every law which gives differential treatment to government or the public bodies in necessary immunity for challenging on the ground of discrimination. The Mahal Chantal Visible Public Corporation Limited, the Sri Sitaram Sugar Limited Union of India, the Supreme Court laid down that the act of the proprietary power without registration and administration quasi judicial is open challenge. Quasi QUASI judicial. The conflict of constitution or governing act of general principle law laid down and it is an arbitration unreasonable that no fair minded authority could ever be made. The observation has been made in the context of challenge to the order of the price fixation of a levy sugar under the Essential Commodities Act 1955. The footnote 8 in paragraph 52 of the judgment following English and American cases as well as Canadian and Australian cases have been collected. Auction cancellation. The cancellation of auction could not be improper whether the competition authority after scrutinizing auction process found that there is no sufficient petition and no such good price could not be obtained. There is no colored or exercise power or arbitrariness. Arbitriness, arbitrariness. The enterprise. The Jarnad Shahu is a state of Chhattisgarh and Sinas Public Commission Private Limited and Union of India. Rajasthan Housing Board, GES Investments and Development Authority Association of Management Studies. Audit alterum pattern. So, to improper, no sufficient competition. And good price could not be obtained and there is no color or exercise power of arbitrator. Audi Altram Patrium rule of Patrium rule of hearing the parties application the mind of the recording and reasoning decisions are the basic elements of natural justice. The judiciary processes are essential that to be conscious of the principle of natural justice, including the doctrine including essential to conscious is essential natural justice, including the doctrine of Audi Alternum Paranum and Manoharam Manikoro at Avuncholo State of Maharashtra. Expunging the adverse remarks, disparaging remarks making against a ministry is liable for expunging such remarks necessary, neither necessary for educating or issue or not the chief minister of the party to proceeding. Om Prakash Charo. Disparaging remarks made against a minister would be liable to be expunged, where such remarks are neither necessary for adjudicating of issue or not chief minister of the party to proceed. Backward areas, discriminating a favor. What do you mean by this? The backward area is discriminating in favor of person residing in backward area permissibly MP oil execution state of Madhya Pradesh. Industrial unit was set up a backward area in instance of state government. Specialized treatment is given to the assuring supply of salinity concession rates of oil extraction. It is held that the decisions are reasonable MP oil extraction. Barons extractions. The prospective mother would have not made to bear a child. Particular sex cannot be equal to the mother who wants. The prospective mother who does not want to bear a child in a particular sex cannot be equal to the mother who wants to terminate the pregnancy, not because of the sex of the child, but because of the other circumstances laid down under the Medical Termination Pregnancy Act. Vijay Sharma is Union of India. Bias and mala fide allegation. The doctrine of bias emerged from the legal maximum nito debate essay. Maxim debate ASC Judix in Kasha Propriashue. This bias is one of the limbs of natural justice. The apprehensive bias can be reasonable if such apprehension exists in the trial judicial order should be initiated and want to impartiality in plays only when the interested attributes of the individual such an attempt to making decisions in favor or to further own case. State of Gujarat R.A. Mehta. Biases and mala fide allegations ought to be approved by cognate and clear evidence. Naresh K. Agarwal Co. and Kanban Financial Service Limited. Consequence on the death of a person prior to execution of legal. The government cannot impose penalty upon the legal successor or non-execution legal deed. Then the prior to execution of the legal deed of person consent and the proceduralities had died and Gurudwara state of Karnataka. Consequence of death of person prior to the execution of lease deed. The government cannot impose a penalty upon a legal successor or for non-execution of lease deed when the prior of execution of lease deed concerned the prejudice died. Okay. Board of Control of Cricket of India. The BCCI enjoys a monopoly. The state of Karnataka versus Gurudwara. BCCI enjoyed monopoly status in regarding the regulation of sport of cricket in India. It exercises autonomous public functions. Hence, it found that following functions of fairness and good faith is activity. Board of Control of Cricket of India and Netaji cricket clubs. Citizenship. Foreigners do not have the fundamental right to obtain Indian citizenship. David John Hopkins is Union of India. The concept of equality. Concept of equality cannot be possessed to commit the other wrong. Kasant Nikwa is GSA Maria Ignore as President of Indo Development Authority. Constitution of Section 377 IPC. Naviti Singh Johar, Union of India, Supreme Court partially struck down Section 377 of Indian Penal Code so far as it criminalizes the consensual sex act because in the company and adult in private space. The main as far as criminalizes constitutional because the company and adult private space. Supreme Court observed that examination 377 IPC surveyed there's Article 14 of the Constitution reveals that the classification adopted under the Act 377 had not reasonable nexus with the object or other penal provision of the Section 375 IPC and POSCO Act. Although penalizing non-consensual carnal intercourse, the Supreme Court held that 377 IPC is a present form as a result of unwanted collateral effect, whereby even consensual sex act of LGBT have been woefully targeted, thereby resulting in discrimination and unequal treatment of LGBT community. Navteej Singh Johar, Union of India. Cross-examination. Cross-examination is an internal part of principle of natural justice. Ayya Ubakam Noharkim Patain, State of Maharashtra. Discrimination. Action of state creates a class within a class violates Article 14 State of Uttar Pradesh Committee of Management. In a differential treatment relating to the water charges given industrial given water as a raw material, there would not be discrimination. PepsiCo using water as a raw material would not be a discriminatory. What a charges given industries give water the PepsiCo Industry Holding in the state of Maharashtra. When challenging was made in statutory provision being discriminating allegation of reputations made specific, clear and unambiguous that there would be improper pleading of All Indian Bank Office Association and Indian Bank of National Bank of India, also like a state of Himachal Pradesh. A deprivation of property in 3A of Constitution would be considered accordance with the law, must be just, fair, and reasonable, and understood the terms of Article Section 14, 1916, and 301 Constitution and KTA Plantation Private Limited State of Karnataka. It is in legislation, its wisdom, it's in prescribed 21 years of age of male who get married and 18 years of age of female get married. Then same could not be termed as discriminatory and even unreasonable or arbitrary. Nethalia, Punjabi, Chittoria, Union of India. Exclusive from accusation would be discriminatory, where it would be ground or reason for quality of his construction. The Shambhala State of Punjab. This investment of matter of public decision of government respect of government of economic matters. The court cannot interfere unless a policy is contract with the Act of Constitution. The appropriate forms of testing of policy of code. Balco Employees Union of India. Mandatory linkage of Aadhaar number with the income tax return. The mandatory linkage of Aadhaar number with income tax return is a constitutionally valid Bino Vishwan Union of India. And doctrine of conservative doctrine of conservativity has been applied by legislation power as it applies judicial pronouncement. Ashya Sharma, Mrs. Chandigarh administration. Doctrine of natural justice. The doctrine of natural justice is not only secure justice but also prevent miscarriage of justice. Its underlying object is a rule of natural justice to ensure fundamental right and liberties of the people. Justice P.T. Dinakaran versus the Honorable Judges of Inquiry Committee. The doctrine is termed as an synonym of fairness or concept of synonym of fairness. Yes, sorry. N- Yes, economy of fairness. In concept of the judicial standard with the most accepted methodology of government actions, Kuman Mandal Vikas Nikam Limited, Girika Shankara Panta. The legislation has the power to schedule the application of the principle of natural justice, either expressly implement Adali Shihal, which is Union of India. The principle of natural justice is to check the arbitration exercise of the state of understanding case and enterprises of state of Uttar Pradesh versus Jagannath Chandrasekhar of the state of Andhra. Non complaints with the principle of natural justice. Muruga, Narayana, Perumale. This order of passing in when an order is passed in exercising power conform statute, you set aside a ground a non-complaining principle of natural justice, then such power can once again be exercised by the compelling principle of natural justice. Vibhul by Mansingh by Chaudhary, state of Gujarat. I don't care. Education rule of admission for medical courses specified length of service for purpose of claiming admission of quota reserve. Um, Quota reserved for children for ex-servicemen valid G. Bina, which is Andhra Pradesh University Health Services. The reservation made in favor of children of ex-servicemen is not one of the category mentioned in the Article 15.4 of Constitution, but such a reservation has been upheld the court on the ground of reasonable classification. Education concession of CST/ST. Benefit of extent of SC/ST students again the free concession cannot be denied by the making in-house classification of SC/ST based on any application of Akil P. Pushkar versus State of Kerala. Equal citizens superior disabled employees are duty want to follow the law as it not open to them to allow the bias on default of lawful rights. The equal permits them to no charity or largeness but their rights to equal citizens of the country. Bhagwan Das versus Punjab State. Constitution of protection of non-citizen. The refugee cannot claim equality of right with the citizen of India. They cannot be above constitutional protection of non-citizen, extending all the provision of the Constitution of Act. Jnana Prakasham is the governor of Tamil Nadu. Equal pay for equal work. Doctrine of equal pay of equal work postulates equal pay for equal work for which who was equally placed in all respect. Uttar Pradesh, Sugar Corporation, Sankti Singh. Supreme Court Employees Welfare Association Union of India and State of Odisha versus Balaram Sahu. Equality. The concept of equality is enshrined in Article 14 of Constitution is a positive compare. If an inequality of inequality has been committed in favor of the equality of a group of individuals, the other cannot invoke the decision of the High Court or Supreme Court and seek and direction the same irregularities or illegality of commitment in favor of state and agencies instrument. Usha Mehta of the Government of Andhra Pradesh. The equality clause enshrined in Article 14 of wide import. It guarantees equality before the law and equals the protection of law with the Territory of India. John Valamatam, Mrs. Union of India. Article 14 cannot be used as an perpetual and inequality and does not envisage a negative equality. It applies only when the individual discrimination is melt out and equal to doctrine of discrimination and based on the exercise of enforcement rights. The equality clause of Article 14 is a positive concept. Such equality cannot be claimed on illegality. State of Punjab versus Kulpreet Singh. Equality cannot be applied when arising on illegality. A general manager of Uttarakhand Jal Santan Lakshmi Devi. A doctrine of equality could not be attracted when there is a benefit or relief confound on the basis of illegality, fraud, or error. Commission of Police Mehar Singh. The claim of equality, State of West Bengal versus SK Colonel Ahmed. The complexity of decisions and making process cannot be defended when the grievance is made before the court of citizen. That is fundamental right of equality has been violated. CM Trivikrama Varma versus Avinaksha Mohanty. It is a well settled fact that a guarantee of equality before the law is a positive concept of cannot be enforced in a negative manner. State of West Bengal versus Deepak Deepakshi Mukeshji and Fuljit Karor with the state of Punjab. As a right of equality, Article 14 of the Constitution is available under the state aid. It cannot be claimed against the unaided private minority school. Sathimbal Sharma of the State Paul Senior and Secondary School. ICS Madhya Pradesh and Mehan Prakar. Remedial measures of control. The remedial measure of the court instead of invalidating the impure law could be taken Mahatma Gandhi Mission Bharatiya Kamgar Singh. Employment of the state. The drastic power under the Article 309 Constitution is required to exercise a manner that does not conflict with any other constitution guarantees right. And Article 14 and 17 of Constitution, Taj Prakhtar Singh, Rajasthan High Court. They deny the public employment of the candidates as solely on the basis of the police report regarding the political affinity of candidate would be afforded the fundamental right of Article 14, 16, 21. The Constitution unless the Constitution the Constitution, unless under the affirmative, considering a likelihood of affect the integrity and efficiency of the candidate, unless there's a clear material indicating involving candidate in subversive violent activities and banned organization. K. Vijayana Lakshmi is the state of Andhra Pradesh. As the state of Maharashtra, which is Rakvasi. Filling up the vacancies are notified. Filling up vacancies over and above the notified vacancies and tantum amounts to filing up the future vacancies are not permissible under the law. Raj P. Nair, the state of Odisha. Equality of promotion, a right of equality and equal eligible employees to be considered promotion of virtual plan of fundamental rights of employee. Union of India, Hemraj Singh and Chaudham. Equal and unequal. Unequals are not only permitted to treat as unequal but also they have to be treated. State Stephen College, University of Delhi. The creamy layer and backwards class is treated as unpar and the flower classes as not entitled to benefit the reservation. It is a creamy layer, it is not exclusive. There will be a discrimination violence in Article 1416 much equal forward and creamy backward areas cannot be treated unequally. Against non-exclusive creamy layer will be Violation of Article 14, Article 16, Article 64 is such an unequal. A creamy layer cannot be treated as equal as it say equal to the rest of the backward class of Indra Shaura Union of India. The equal treatment of unequal, nothing unequal. It is put to a category taint unless a para of a wholly ancestors with arbitration unconditional being violated of Article 14 in the Constitution. Onkar Lal Baji was Union of India. Execution action. Occasionally, administration action that is violates equally comes up with the scrutiny before the vote. Such action may be based on the statute or being purely execution action or administration nature. It is a non-statutory character. In either case, a statutory or non-statutory order of execution which is arbitrary may be scaled. Gopi Chand was the Delhi administration, iron metal traders and versus Hashki, Vishkanu, Hundal, which is state of Madhya Pradesh, Indian Express newspaper, private owners Union of India, Shuman Gupta, state of Jammu and Kashmir. Constitution of India. Here, the court is not concerned with the validity of parent act, but it's a mode of exercising power of other flexibility. Article 14 is a bill flexibility and allow reasonable classification passed on objective basis. Premium granites the state of Tamil Nadu. 8. Flexibility. Aid in grant in need. Non-extensive grant in need by the state. Grant in need. Grant, okay, what is grant in need? By state to non-government colleges, but grant exemption to the non-government schools or the facility. It's a patently discrimination state of Maharashtra. This is Manubai Bragji Vashi. Yeah. The court must decide the challenges of legality on the order of allotment of land by the government on the basis of material available when the government High Court is examining challenges, not basis of what may comes future. Legality, which is state of West Bengal. Granting largeness. The state government can receive the number of discriminatory license in particular district by the two, but is only granted to the third license in particular districts, as well as by the applicant cannot grant a license in matter of right. State of Kerala versus Kankand distilleries. The government has to act fairly without any semblance of a discriminatory matter of granting license. It cannot act arbitrarily in the manner which may benefit the private party. Humanity state of Madhya Pradesh, West Bengal. Granting license, it's not necessary state of government to for granting license for establishing new industry which is advised and invite offer or putting up a new industry of state. It is entitled to negotiate this who can come up with the offer and set up the new industries. The state of Kerala when Kandan discrimination. Illegal action. Equality of clause cannot be applied to the discrimination of illegal act. Ekta Shakti Foundation, government NCT, illegality cannot be perpetuated. When unauthorized construction of appellant is violation of building by innocent terms and concern, it is a lease deed particular. Some advertising can granting license is not advertised. It is not necessary for the state government for granting license for establishing new industries which should advertise, invite, offer, or putting new industry in. Not necessary. So it is entitled to negotiate with those who comes up with the offer to set up the new industries. Illegal acts. Equality clause cannot be applied to a legitimate and illegal act. Ekta Shakti Foundation was the government of India. Illegality cannot be perpetuated. Perpetuate. Whereas in where the unauthorized construction of appellant is a violation of any building bylaws and terms and conditions, at least the perpetuate affecting the proper planning in industrial area. He cannot claim that beneficial extended to other which illegal should be extended to him. This particular proper planning in industrial area. He cannot claim the benefit extend to others through illegal, though illegal should be extended to him. Article 40 provides then positive equality and cannot negatively equality. which are properties by the state of Uttar Pradesh. Interpretation. There is no discrimination where owing and wrong interpretation. Some producers are exempted. Yes, calls VCB. Land acquisition. Acquisition should be made determination the amount of compensation for acquisition of land under the defense of Act 1971. Here the land acquisition 1984 is reasonable and manageable. And such a classification is found intangible, differential, rational in relation of object must be achieved by the legislation of question. Union of India versus Chanduram. Land ceiling. Section 47 urban landing ceiling of regulation 1947. It is not unconstitutional on the grounds it makes certain special provision regarding Hindu undivided family. Such a family is not a person. It should not be treated as a single unit for the purpose of ceiling element. Under Section 47, the individual members, major or minor, are separate ceiling. Pratima Paul is competent authority. A legitimate exception. There is a legitimate exception to create permission to run the minority institution. And secretary can own district Muslim Education Association in the state of Kerala. The premium statue of service available to the patient for patient by doctors arising legitimate exceptions. Malya Kumar, Ganyulu, Visesho Kumar, Mukherjee. Limitation. Broadly speaking, judicial decision interpreting Article 14 with recognizing paramount nature of fundamental right, recognizing need of constitutional of reality, and certain limitations often stand than equality before the law guaranteed by the first place of article of such a negative concept, which is second part of more positive concept. Neither part of articles above recognize exemption and equality of ground. There's a while the first part of mentioned this Desai law of constitution, ninth edition page or something. The second corollary the rule of law would be out of the privilege out of the arbitrary. But the constitution does not give the privilege of president on the governor or the members of parliament. The state decision over some of the provision of the interpretation result of the certain elements of discrimination. For example, the liability of a state as an inter is even today in India is not necessarily the same as the liability of a private employer. According to the current theories, no suits lies against the government for an inquiry the course of exercise of sovereign function of the government. State Rajasthan and Vidyavati. There is Shyam Sundar was the state of Rajasthan. Malafi, the action taken by the state is undue haste may held by the Malafi due interpreting Kohalam, which is state of Punjab. It is a division is taken a bona fide and in public interest on the mere fact of decisions may be ultimately provide the wrong would be itself not be ground the whole affair decisions of mala fide. Arun Kumar Agarwal's Union of India. When allegations of malafide are made, the person against whom the same is alleged need to be implemented on the parties to be proceed to enable him to answer the charges. Ratnagiri Gas Power Limited is it is a termination of present malafide should be quashed immediately. The state of Karnataka. Newspaper, the state cannot view the equality doctrine contained in the Article 14 of Constitution of it. A resort of theory, take it or leave it. The bargaining power of the state and the newspaper is a matter of release of advertisement is unequal and just condition thrust upon the state which attracts the wrath of Article 14 in the Sun Times of State of Uttar Pradesh. Panchayat removal of members. UP Panchayat Raj Act 1947. Section 17 14 the empowers member of the Gram Panchayat to remove the Pradhan of Gram Sabha to the motion of non-compliance. It is not unconstitutional. It is not unconstitutional. It is infringing democratic of Ram Bele State of District Panchayat Rajautree. Pension. By erroneous interpretation of rules and pension benefits are granted and someone, it would not mean that its said mistake would be perpetuated by the direction of the court. Union of India, the Rakesh Kumar. Editions of D.S. Nakara, Union of India. This can be invoked and give liberation pension of these who was already retired prior to liberation, state of Rajasthan or Prime Rajasthan. But it cannot be applied to irrespective of the fact of the case KL Rati Union of India. Retrospective reduction of petition by already become liable to employees in unacceptable of void. Chairman of Railway Roads C.R. Rangaramia. The principle of natural justice. Hearing the parties' application of mind according reasonable decisions and basis of the elements of natural justice. The adjudicative process essential has been consequence with the principle of natural justice, including doctrine of Audi Alteram Patri, Manoharan Manukro, Archivist State of Maharashtra. Court is not bound to issue notice of complaint and hear the merits in relation to the release of the person accused to viable offences such as defamation. The cancellation of bail is on ground of completion was not hard and proper. Rasikal versus Kanchan Vadari. The person cannot be allowed to raise a plea of violation of principle of natural justice who refuse to appear in spite of a receipt of the notice of appearance. P. Mano Mohana Sundaram, which is president of ICA. The person cannot be allowed to raise a plea of violation of principle national justice who refused to appear in spite of his pay. That's what notice. P. Mohana Sundaram is president of ICA. Not speaking of order is opposes in the principle of national justice. Arjun Jawak, State of Uttar Pradesh. The cross examination is an integral part of principle and the natural justice. IN Noor Chan, Patman, State of Maharashtra. Natural justice, strict observation. The institution of natural justice is one cannot insist on strict observation of after the principle justice, principle natural justice. Ex-Army Men Protection Services versus Union of India. Procreation discrimination. Article 14 forbid discrimination in the matter of procreating. Example: State of West Bengal, Anwar Ali, State of the Orissa versus discrimination das. Kairangi Raviva Rawat, State of Saurashtra, Special Court Bill, and Chowpra versus Union of India.